3, 2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon and welcome to the Tennessee Court of Appeals. First of all, I want to tell you how much we appreciate you participating in oral argument via Zoom. It's a way for us to continue to do business and keep everyone as safe as possible. I also want to remind everyone that this is being live streamed. So everyone, I don't know how many people are watching it, but it is being live streamed and it will also be placed on the AOC website so it can be viewed later on. Even though we are utilizing Zoom, I want to remind everyone that the same procedures and rules will apply as if we were standing in court today. Essentially, that means that each side gets 15 minutes to make its oral argument, and if you're the appellant and you're reserved rebuttal time, you will receive that rebuttal time as well. Before we start, though, I want to introduce your panel for this afternoon. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. I do not anticipate encountering any technological problems, but if we do, everybody just remain calm. We'll get it fixed, and we will also make sure that it doesn't prejudice anybody in this argument. Ms. Tebner, anything we need to take up before we get started?
No, Your Honor.
You may call the case then.
Amy Elizabeth Luker versus Terry Eugene Luker.
And we will hear from the appellant. You're muted, I believe.
Thank you, sir.
There you go.
May I please the court? I'm Venus Niner, and I represent the appellant in this case, Terry Luker. This case stems from a civil contempt petition. There were some other issues at the time, but that was the remaining issues that came to this court, wherein the Ms. Luker alleged that Mr. Luker had failed to comply with certain terms of the MDA. The MDA provided that Mr. Luker should provide life insurance to Ms. Luker and provide proof of that by a date certain. And it is undisputed that after the filing of the petition, but before the hearing in this matter, that he had done so and had purged any potential contempt. There was a hearing in this case. The trial court made a finding, and it was a hotly contested issue between the parties as to whether or not Mr. Luker was in contempt. And the last thing that counsel for Mr. Luker asked the court was to clarify whether indeed they found him in contempt or not in contempt. And the court basically said that he was in contempt at the time of the petition, but that at the time of the hearing, he was no longer in contempt as he had purged himself. And actually stated word for word, you can put that in the order. Okay, had that been put in the order, the way the judge ruled, we wouldn't be here. Mr. Luker presented two issues to this court. The first one is whether the trial court committed error in entering a written opinion that contradicted the court's ruling, the court's oral ruling from the bench. And the second issue was whether the trial court committed error when it found Mr. Luker in contempt. I would argue that resolving the second issue may resolve all issues in this case, whether the trial court committed error when it found Mr. Luker, and set aside all the issues related to how the order was entered for this argument. The question is whether, having purged himself, the court could still find him in contempt at the time of the hearing. Ms. Luker relies on 29-9-104, Tennessee Code 29-9-104. It's pled in her petition, alleging that Mr. Luker failed to perform a required act, that act being providing proof of the life insurance policy. The pertinent part of 104 states that if the contempt consists of an omission to perform an act which is yet in the power of the person to perform, the person may be imprisoned until the person performs it. Mr. Luker had already complied with the order. In a sense, he had filled the only hole that was vacant. There was nothing else that he could do. Requiring him to fill that hole again would be an impossibility. Therefore, we would argue that there was no expectation that he could comply. There was no expectation that he could purge anything. And there was no power the court had to coerce him to, as it was already done. In a civil contempt proceeding such as this, the person in contempt has the keys to the jail in their pocket. And clearly, having already complied, Mr. Luker couldn't free himself. There was nothing more that he could do. He couldn't use the keys that are alleged to be in his pocket. Miss Luker relied on overnight transportation. It's in their in the order that they prepared. Overnight speaks about TCA 29-9105. It is a prohibited act. It is an act which a court tells you not to do. It doesn't address an omission at all. Overnight states, when the contempt consists of the performance of a forbidden act, the cessation of the contemptuous conduct after the entry of the order prohibiting that conduct does not preclude a finding of contempt and an award of damages. Now,
And are you arguing that that I'm not sure that you are arguing this, so I just want to clarify it. Apparently, what ultimately happened here was that attorney's fees were awarded because Mrs. Luker the court determined that Mrs. Luker had to bring the petition in order for your client to comply with his obligations under the MDA. Are you arguing against the award of attorney's fees, or just the idea that he shouldn't have been held in contempt?
Just the finding of contempt.
All right, thank you.
Let's see. The second issue that Mr. Luker put forward was whether the trial court committed error by entering a written opinion that contradicted the ruling from the bench. Ms. Luker's response to that issue in her brief was that the order did not materially differ from the oral order. The written order didn't materially differ from the written order. In essence, they're arguing that finding him in contempt is not materially different than finding him in contempt. That is basically like saying black is not different than white. I don't think that needs a lot of development. Second, Ms. Luker argues in her brief that even if the written order was materially different than the oral order, that it was not reversible error, arguing basically that the court could change its mind. They cited several cases, and each of those cases had some procedural change. There was another hearing. The order that that was being challenged in the Court of Appeals was a temporary order. They cite no case for the premise that without more, without a hearing, without additional evidence, without any notice to either party, that the court can orally order one thing and then write an order that states another thing.
Is it your position that the court can't do that?
That's why I said it may be easier to solve the second issue first, whether he could be found in contempt. Because if he cannot be found in contempt, this issue probably doesn't matter. But I believe that there has to be something, additional evidence, something to go from an oral finding of fact and conclusion of law to a written finding of fact and conclusion of law that differs without more.
So your position is that if the trial court renders an oral decision today and then ponders it overnight and decides, perhaps I erred there in my decision making, the court can't change its mind without some additional proof or something else happening?
I think the only response I can make in this case is this isn't what happened. The order wasn't really prepared by the court. The order was prepared by Ms. Luker's attorney. It was submitted to the court. There were some issues related to, we tried to undo the order and the court said, no, this is my order. I think part of the issue is that the court did not write the order. There is no indication that the court said, I'm pondering this and I'm changing my mind. There's only evidence that Ms. Luker submitted an order, the court signed it and adopted it without more.
Did you point that out to the court that the court had changed its mind? Is that what the court wanted?
I filed, yes. And I submitted a transcript and filed a motion to alter, amend, tried to get some avenue back into court to show the court this is not what we believe the court ordered, and we got no relief.
So the court was aware of that. So that would seem to indicate that perhaps the court did change its mind.
The court was aware of that, and the transcript was filed after the order was signed, after the order was entered.
All right, thank you.
Mr. Donner, did the trial court not state in its subsequent orders that it had fully reviewed the orders submitted by counsel and read it and agreed with it?
Not in the original order, but in response to our motion to alter, amend, and their denial of that motion.
But yet you're saying that it's your argument that this was not the court's own reasoning and conclusion.
Yes. Okay. The other issue that's before the court is Ms. Luker's reply brief. Or our reply brief, that Ms. Luker has filed a motion to strike. Ms. Luker brought up an argument. She brought her own issue to this court of whether she's entitled to attorney's fees. We argued in our reply brief that the behavior of Ms. Luker in not submitting an order that matched the court's ruling or the transcript once it was provided to them, that is unclean hands, that it continues here when they cite cases for one proposition when it really doesn't apply, that these are factors that the court can take into consideration when making a discretionary decision, the behavior of the parties. And that is my time.
Thank you. We will hear from the appellate.
Good afternoon, Your Honor, and may it please the court. My name is Sean Aiello, appearing on behalf of appellee Amy Luker to ask this court to take two actions. First, to affirm the trial court's final order, and then second, to grant appellee her reasonable attorney's fees incurred with defending against this appeal under alternative legal theories, including under TCA 27-122 as defense against a frivolous appeal, and then second, under TCA 29-9-104 as cognizable damages under the civil contempt statute. And finally, as a prevailing party in a civil contempt action and alimony enforcement proceeding under TCA 36-5-103C. Your Honors, appellant presents only one proper issue for appellate review, and that is the first issue they discuss, which is whether the trial court committed error when it found Mr. Luker in contempt. Notably, appellant does not contest any of the factual findings made by the trial court derived from the undisputed proof and testimony provided by appellee at the final hearing, nor does he seek reversal of the award of damages that was awarded under alternative legal theories. The only question presented is if, provided the undisputed facts of this case, the trial court could legally issue findings of civil contempt under 29-9-104 in its final order. Appellee respectfully asserts that the trial court did not err in its ruling and requests this court uphold the trial court's final order for 3 reasons. First, Mr. Luker's actions in failing to obtain and provide life insurance as required under the MDA and the final decree of divorce constitutes contemptuous behavior. Second, the essential elements of TCA 29-9-104 were proven at trial and are undisputed on appeal. And finally, under applicable case law and statutory authority, the trial court had the authority and discretion to issue findings of civil contempt and did so in this case. Essentially, this case boils down to one significant legal question, and that is whether the trial court has the discretion to issue a finding of civil contempt under TCA 29-9-104 when a party ceases contemptuous behavior prior to a final hearing. Here, appellee argues the answer to this question is clear based upon a straightforward reading of the applicable statute, as well as the legal analysis that is brought forth under the Tennessee Supreme Court case in its 2005 decision of Overnight Transportation Co. versus Teamsters Local Union. The outcome of this legal question, however, ultimately has zero substantive impact on the underlying award of damages issued by the trial court under the alternative grounds provided in the final order. Whether this court removes the label of civil contempt as it applies to the actions of Mr. Luker has no ultimate bearing on the damages awarded in this case. The primary issue presented by appellant on appeal concerning whether this trial court could have found Mr. Luker in civil contempt is one purely of law, whether given the undisputed facts of this case, its ruling can be sustained. There is no appeal of whether Ms. Luker proved at trial the 4 essential elements of providing for civil contempt, but does allege that given the satisfaction of these elements, that the trial court could not have found civil contempt when, after months of litigation and right before trial, appellant ceases his noncompliant conduct and produces previously ordered documentation. It's undisputed that appellant ceases behavior during the trial court proceedings, as noted in the final order and during the trial. However, recognizing that cessation necessarily requires a finding that Mr. Luker's previous actions were in fact in violation of a court order and contemptuous. The Tennessee Supreme Court examined a similar scenario in the case cited Overnight Transport Co. In that case, the court examined the application of TCA 29-9-105, which was correctly pointed out by appellant, addresses the performance of a forbidden act and the cessation thereof during the course of litigation. Notably, that court found that when the contempt consists of the performance of a forbidden act, the cessation of contemptuous conduct after the entry of the order prohibiting that conduct does not preclude a finding of either civil contempt or an award of damages. Neither the plain language of TCA 29-9-105 or the scope rule of the contempt statutes of 29-9-1023 requires that a disobedience of a court order be ongoing. A review of this question is important to examine the statutory language both of 104 and 105. 104 was amended through legislation in 2011 to add in language that was not present in 2005 when the overnight transport case was first decided. That amendment added in the ability for the trial court to find and award damages as it relates to the omission to perform an act. Overnight therefore stands for the proposition that absent restrictive language within narrowly construed statutes, which are contempt statutes, precluding findings of contempt, the trial court may make findings of civil contempt as well as award damages, even if the contemptuous conduct ceases prior to a final hearing. Neither at the trial court level nor on appeal did appellant provide any legal authority contesting this position or standing from the proposition that the trial court cannot make a finding of civil contempt in the face of cessation of contemptuous conduct, relying instead primarily upon conclusory statements. It's important to note that in neither the oral court ruling or in the court's written ruling did the court not say that Mr. Luker had ceased his contemptuous conduct during the course of these proceedings. That is an undisputed fact. The question seems to be primarily focused on the label of whether the court can say that Mr. Luker was in civil contempt for failing to comply with the court's order, and then make the rest of its findings accordingly. Specifically, as identified as issues that have been raised during the course of these proceedings, the appellant raised two primary issues on appeal. The first one has been discussed, but the second one, whether the trial court committed error by entering a written opinion that contradicts the court's ruling from the bench. That issue was neither briefed in the appeal document as required under Rule 27, nor was it materially discussed in these proceedings. The appellee contends that because Mr. Luker failed to brief that material issue on appeal, he has in effect waived that issue, as this court has upheld in cases such as Blair v. Badenhope from 1996. In that case, this court examined whether an issue raised on appeal and then no issues were discussed related to that issue, whether the court could properly hear and adjudicate the issue on appeal. Ultimately, this court found, and has held consistently since, that if an issue is raised but not briefed, the appellant has effectively waived that issue on appeal. As stated in Blair v. Badenhope by this court, parties cannot expect this court to essentially do their work for them, and it has no duty to verify unsupported allegations in a party's brief, or for that matter, consider issues raised but not argued on appeal. With respect to the second issue presented, which was discussed in oral argument, Mr. Luker raises on appeal through his reply brief several alternative avenues, which he now relies upon on appeal to support his argument that the court could not have found Mr. Luker in civil contempt, and also in support of the previously waived argument of whether the court entered error by entering a written opinion that contradicts the oral ruling from the bench. Specifically, as identified in the pending motion to strike portions of appellant's reply brief, Mr. Luker raises for the first time on appeal 4 specific theories not previously discussed. The first would be unclean hands. The second is the court's apparent waiver of a duty to draft its own order. Third, alleged misconduct and malfeasance by Ms. Luker, as well as her counsel, both in the trial court and on appeal. And then finally, a novel due process argument. Neither of these issues were discussed or raised either at the trial court level or in the appellant brief, providing appellee an opportunity to respond to the same through its response brief. Beginning with the first allegation of unclean hands that Mr. Luker relies upon in defense, or presumably as a bar to Ms. Luker providing her own defense to the pending appeal, this argument is one of equity and is applied in courts of equity, and is admitted by appellant in the reply brief that this issue was not discussed before the trial court, but is now asking this court to apply its equitable theories as a bar to Ms. Luker, first asking for attorney's fees in response to the appellate brief, but also essentially to act as a bar to providing an effective opposition to the appeal in this case. An equitable argument is one that is reserved primarily for the trial courts. It is not before this court, and is extensively heavily fact dependent and requires fact finding, which is not necessarily the purview of the Court of Appeals, and certainly not under this case. The second issue, which was discussed materially during appellant's oral argument, relates to the allegation that the trial court had effectively waived its responsibility and duty to draft its own order and entering an order submitted by appellee. That issue was not briefed on appeal, nor was legal argument provided supporting a basis for that argument. Therefore, because this is now the first time that has been raised on appeal, Ms. Luker would rely upon Denver area meat cutters and employers pension plan v. Clayton, a Tennessee Court of Appeals case out of 2006, to argue that inclusion of new legal arguments and theories at this stage of litigation is fundamentally unfair to the appellee, as there is an effective bar to the ability of the appellee to argue against in a responsive document or prepare for the same on appeal. The final two issues raised by Mr. Luker through his reply brief the allegations of misconduct by counsel and Ms. Luker, as well as due process allegations, none of which appear either in the trial court record, allegations of the same, or in the appeal brief itself. The first time that argument has appeared on that particular issue is peppered throughout the appellant's reply brief. In effect, Ms. Luker alleges that the only issue before the court to decide is the second issue presented under the appellant court's brief, the appellant's brief, of whether the trial court could find Mr. Luker in civil contempt, given the specifically essentially unassailed facts of the case. As a result of defending against this issue on appeal, Ms. Luker has raised one issue of her own for consideration. And that issue is whether she should be entitled to a grant of attorney's fees under three alternative legal theories. The first being TCA 27-122 for frivolous appeal. Under that statute, this court has the authority to determine that if an appeal from a court of record was frivolous or taken solely for the issue of delay, the court may, either upon motion of a party or on its own motion, award damages to the appellant, which may include but may not be limited to attorney's fees. In examining this particular question, the court must look at the issues raised by appellant on appeal. The first issue, which was not raised and not briefed, and materially could not have a chance of success because that issue was waived. As this court has found in GSB Contractors, an appeal case from 2005, an appeal is deemed frivolous if it has no chance of success. On one of the most significant issues of their appellant brief, appellant did not brief that issue and therefore has zero chance of success on the same, as that issue was waived on appeal. Additionally, the remaining issue as to whether the trial court erred by finding appellant in civil contempt, the only legal authorities cited by either party on this case do not hold against that particular ability of the trial court to make a finding of civil contempt. Both parties rely upon, well, essentially, appellee relies upon the overnight transport case. Appellant does not cite any specific legal authority that contradicts that holding or the legal analysis provided by appellee in her responsive brief, tying the analysis to 105 to the omission to perform an act under 104. Without an issue that has been substantially briefed or legal argument presented, that appeal also has no chance of success on the merits. Additionally, as an alternative basis, Ms. Luker seeks fees as consequential contempt damages under the same legal theory they were awarded in the trial court. The ultimate issue of this case stems out of Mr. Luker's noncompliance with explicit terms of a marital dissolution agreement, and in particular, Section 12 of the MDA, which deals with an alimony security provision. Under TCA 29-9-104, as well as the domestic statute of 36-5-103C, the trial court had the authority to award attorney's fees, which it did, in actions for civil contempt to a prevailing party and issues concerning alimony or other particular issues. The trial court additionally awarded fees under the alternative legal theory of the marital dissolution agreement, which held that as an enforcement provision, if action was necessary to bring litigation to enforce Mr. Luker's compliance, or Ms. Luker's compliance for that matter, fees would be a mandatory award. Ultimately,
Are you pursuing fees under the MDA?
Ms. Luker is not at this time, due to the particular posture of the case. What's on appeal is that finding of civil contempt. I find it hard to squeeze that into the MDA language itself because it's not necessarily an enforcement mechanism of an MDA. Moreover, it's more the statutory TCA issue of a contempt being enforced through the domestic statutes. So in conclusion, Your Honor, appellee respectfully requests the court uphold the trial court's final order and award her fees in pursuit of this defense. Thank you, Your Honors.
Thank you. We will hear the rebuttal from the appellant.
The first thing that the appellant would like to address is the holding an overnight. It specifically says that when the contempt is based on a forbidden act, it could have said when a contempt is based on anything else, but it said a forbidden act, which seems to limit that holding to that situation. It didn't include, and it doesn't say that 104 is included in that analysis.
Do you
So
have the authority that says that it is limited to a forbidden act?
No, just the language in overnight itself that says when the action is a forbidden act specifically. The court says it itself. It doesn't include 104. Other than that, no. Ms. Luker brought forth her own issue. And it is an issue that this court has discretion. It is not a mandatory award of attorney's fees if the court should find against Mr. Luker. I do not believe that in his brief, Mr. Ayala or Ms. Luker argued that they were entitled to attorney's fees based on the MDA. They just went forward on 27-1, 122, 29-9, 104, and 36-5, 103C. Okay. As long as a court has discretion, information such as the conduct of the parties and the history of the case are relevant in exercising the court's discretion. An award of attorney's fees is not, in this situation, is not mandatory. And a question that just sits there is when the court says specifically, but at the time of the hearing, he, referring to Mr. Luker, is no longer in contempt because he has purged himself. You can put that in the order. Why was an order not submitted that put that language in there? I would argue that that is bad conduct on the part of Ms. Luker, and that the court should take that into consideration. And my time is up.
Thank you. Thank you, counsel, for your argument. We'll take this matter under advisement and we'll attempt to render an opinion at the earliest possible date. We appreciate you again participating via Zoom. Ms. Tivner, anything we need to take up before we recess to the call of the next case?
No, Your Honor.
All right, you may recess court.
This honorable court is now in recess until 2 p.m.
Thank you. Thank you, counsel.